Federal High Court resumes new legal year. Court permits INEC to recall Senator Milaye. Court resolves Abdul crisis, sacks Dokpesi as Board of Trustees Chairman. Hello and welcome to another interesting episode of Judiciary Watch. We have a handful of judiciary news packages for you. Plus,
so that's why the Court of Appeal, for instance, is the tribunal for the presidential election, and then the various election petition tribunal has to be set up by the President of the Court of Appeal. And these are...
On our Judiciary Watch discussed today, we'll be looking at post-election legal disputes in Nigeria, and Senior Advocate of Nigeria, OKUTEPA, is our guest. Please don't go away.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like
this. In a bid to ensure speedy dispensation of justice, the federal government is set to swear in 10 new judges for the Federal High Court before the end of the year. Chief Judge of the Federal High Court of Nigeria, Justice Ibrahim Auta, stated this during the special court session marking the commencement of the 2017 and 2018 legal year of the Federal High Court.
This is a special court session marking the commencement of the Federal High Court's new legal year. Declaring the legal year open, Chief Judge of the Federal High Court of Nigeria, Justice Ibrahim Auta, expressed the readiness of the judiciary to deliver high-caliber legal services, which is evident in the current state of judges' welfare, upgrade of the Lagos Division of the Federal High Court, as well as the appointment of 10 new judges to enhance the court's manpower that will amount to a speedy dispensation of justice.
The most difficult stages in the appointment process have been taken care of before now. We have also invested in the health of our judges by ensuring that they undertake yearly medical checkup. Those who have health challenges are assisted to get medical treatment even outside the country, if need be. We have done it to several judges, treatment abroad.
For his part, Minister of Justice and Attorney General of the Federation, Abubakar Malami, there is a need for judges and other staff of the nation's judiciary to begin the new legal year with new skills that will upgrade the nation's judiciary. He was represented by the Solicitor General of the Federation, Tayo Akpata.
The 2017-28 legal year is indeed unique, as it is the first after the baton of leadership of our judicial arm of government passed to His Lordship, the Chief Justice of Nigeria, Honorable Justice Walter Onoga GCON, on March 7 this year.
With the commencement of Judges' Conference on Wednesday and the swearing in of the newly appointed Senior Advocate of Nigeria on Monday, the new legal year promises to give a new face to the Nigerian judiciary.
The senator representing Kogi West Senatorial District, Dino Milaye, has failed in his bid to stop the Independent National Electoral Commission from proceeding with its recall process. Justice Nnamdi Dingba of the Federal High Court, Abuja, in a judgment on Monday, dismissed the plaintiff's application seeking to nullify the recall process for lack of merit.
According to Justice Dingba, the petitioners, which are Dina's constituents and INEC, are not under any obligations in line with Section 68 and 69 of the 1999 Constitution to serve copies of the petitions to the plaintiff before embarking on the exercise, as was argued by Milaye's lawyers.
It was premature that they rushed to court, and what they wanted to do was to just come and then scatter everything, put impediment on everything. But I'm happy the court has clearly shown that it is not the responsibility of my clients and that of INEC to really serve the plaintiff with papers of this thing. If they want anything, then let them go ahead. If he's lucky enough to force the verification at that level, or is lucky enough to ensure that the referendum does not succeed, then that is the end of the whole thing. But if he's unlucky, he goes.
Justice Dingba also held that the senator's suit against INEC was hasty, premature and presumptuous, and that he did not explore all internal remedies available for him in the Constitution. A similar suit filed by the All Progressive Congress in Kogi State suffered the same fate. With these judgments, the Independent National Electoral Commission is expected to continue with the recall process of Senator Dino Melai.
Justice Yusuf Halilu of the FCT High Court has dismissed the suit filed by Raymond Dokpesi, asking the court to stop the former interim national chairman of newly established Advanced People's Democratic Alliance, Kabir Shitu, and the interim national secretary, Emeka Okengwu, from parading themselves as officers of the party. In the judgment delivered on Thursday, Justice Halilu held that by virtue of ABDA Constitution and the communication between the Independent National Electoral Commission and the chairman of ABDA, which has been proven by documentary evidence, Shitu and Okengwu remain authentic executives of ABDA, while Dokpesi's position as interim Board of Trustees chairman is null and void.
These are members of the newly created Advanced People's Democratic Alliance, ABDA, celebrating the outcome of the judgment of the legal war that almost crashed the newly created party. While delivering the judgment on Thursday, Justice Halilu stated that it is natural for the law to rely on evidence, and that documentary evidence tendered by the defendant, which includes a letter from ABDA to INEC registration form, and a letter from INEC to the defendant, shows that the interim national chairman Kabir Shitu has been communicating to the Independent National Electoral Commission in his capacity as ABDA chairman, even before the acclaimed date of his appointment by the interim BOT chairman Raymond Dokpesi. He added that the appointment letter signed by the BOT chairman Raymond Dokpesi has a thick cloud of doubt and is an attempt to misdirect the court, and that since Dokpesi has not been an ABDA member for 5 years, his position as interim BOT chairman according to ABDA Constitution is null and void. Justice Halilu then dismissed the suit and declared Shitu Kabiru as the authentic chairman of the Advanced People's Democratic Alliance, ABDA.
As a man whom people thought you have integrity, show to the world today that you have no integrity. Because if you have integrity, you cannot go about lying to Nigerians that you are BOT of a party that you don't belong, a party that you are sent to destroy. And the Constitution has affirmed to Nigerians that they have a brand new party, a party that is there for them, a party that is going to help both the government and people of Nigeria to take impunity, to take those people that has ruined this country, those people that are embezzled the country money and milk Nigeria into nothing.
Thank God for this very resound judgment delivered by my Lord, and it is so obvious that the things have been spelled out. Nobody will come and use somebody's name in his back and succeed, because as the court said in the judgment that you cannot build a castle on nothing. You must have a foundation. The foundation of this party is not to deceive people.
The legal tussle, which almost threatened the existence of the party, is now resolved. It is hoped that the aggrieved parties will adhere to the judgment and put hands together to enhance the democratic process of Nigeria.
This is Judiciary Watch. It's time for a short break. When we return, Judiciary Watch Discuss is next.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like this.
Post-election legal dispute has been a phenomenon since the enthronement of democracy in Nigeria. On today's discuss, we'll be looking at its constituents and legal backing. This will come to you after the background report.
Post-election legal disputes are disputes arising from election results where aggrieved parties seeks to nullify election results through the help of either an election petition tribunal or a court of competent jurisdiction. Here in Nigeria, post-election legal dispute has led to the reinstatement of several persons into electoral posts, as well as relieving others of their supposed electoral positions. What makes post-election legal dispute an inevitable reality in Nigeria is the fact that it is being backed by the law under the platform of the Electoral Act. The Electoral Act is a legal document containing a list of regulations and guiding principles for the practice of elections in the country. So far, some senators, governors, members of House of Representatives and state houses of assembly, local government chairmen, and even executives of political parties have been relieved of their positions in various legal battles under the Electoral Act platform.
You just watch Judiciary Watch.
Because there's no program that is like this.
Well, here at the law office of J.S. OKUTEPA, SAN and Co. He is a senior advocate of Nigeria, and today he will be educating us on post-election legal battles. It's an honor having you on this episode of Judiciary Watch, sir.
It's an honor having you too. Welcome to this little office.
Thank you for having us, sir. Can you tell us what constitutes post-election legal battles? What does it mean?
Well, what constitutes post-election legal battle? I think the question should be, what is post-election dispute? Because I see no battle in election. The election should be an issue of exercise of the right. But post-election disputes are disputes that arose after the conduct of election or during the conduct of election, but which are justiciable or which are supposed to be fought either in the court or in the tribunal to determine who the real winner of the election is. And so that's why the Court of Appeal, for instance, is the tribunal for the presidential election, and then the various election petition tribunal will be set up by the President of the Court of Appeal. And these are set out in our Constitution and the Electoral Act to guide you on what you need to do. And under these post-election disputes, there are certain grounds that you must have as a ground of petition. So I prefer to call it post-election dispute rather than post-election battle, because battle is fought on the field with soldiers, with ammunitions. Disputes are resolvable in the court of law or through mediation, arbitration, and conciliation. So it is post-election disputes that is recognized in our law, not post-election battle.
Okay, so from what you have just said now, there are two laws that give backings to election petitions.
Yes. Basically, there are two laws: the Constitution, which is the ground law, and the Electoral Act, which guides INEC and political parties and all the stakeholders in electoral processes in the conduct of election. But what I was trying to also explain is that it is not all malfeasance or all wrongdoings prior to election that are justiciable before the Election Petition Tribunal. For instance, under the Electoral Act, there is a provisions for pre-election disputes. That is conduct of parties, primaries, and all other processes. If somebody fills INEC form and he lied on oath, where you need to go, what you need to do, those are pre-election disputes. Then post-election disputes are disputes that arose out as in the process of conducting the election. So you must be careful as a lawyer not to mix the grounds for petition with the ground that is pre-election, because once you mix them, even though you may have very good complaint, you are likely to be met with a lot of issues, objections, and rulings that the grounds of your petitions are pre-election and not post-election disputes. So that we need, as lawyers, we need to be very careful where to situate and compartmentalize our clients' courses of action. So now that we're concentrating on post-election disputes. It must be a dispute that arose, one, in the course of conduct of election, or in the process of calculating or collating the results. And the Section 138 of the Electoral Act is very clear as to the grounds of presenting the petition. So anything outside those grounds, though may have arisen within the conduct of election, cannot be a grounds to continue to present or a ground to focus on in the presentation of your petition as part of the post-election dispute.
The election petition, as we understand, has a time frame of 180 days. Is there any rationale for setting the time frame for 180 days?
Before the amendment to Section 285 of the Constitution, the election petition in Nigeria, the trial period was not fixed, particularly with the coming to being of the civilian dispensation. And you recall that the election petition in Anambra that eventually brought in Peter Obi and that removed Governor Chris Ngige from office lasted almost 3 years. And in a situation where the losers of the election was allowed to remain in office in the course of trying the petition, and he would have spent substantial part of the tenure of office, was considered to be very, very unwise. And so the lawmakers decided in their wisdom to fix time within which to conclude proceeding. But this was not the first of its kind. Prior now and during the Zero Party and the 1998 period before we transited into civilian democracy, we used to have provisions in our military decrees that set time frame within which to conclude election, and it was 30 days. Then we were not doing what we call front loading, longhand, and witnesses were called, and people, petitioners were able to prove their petition in most cases, and in some cases because of the delay antics of some colleagues and some lawyers, the petition will lapse. So the lawmaker this time around considered that 180 days was sufficient to do and try petition and judgment delivered. They also fixed 60 days within which to conclude appeal at the Court of Appeal and 60 days at the Supreme Court for the appeal that goes to the Supreme Court. So the rationale behind that, therefore, was that no person who is not a winner of election should be allowed to remain in an office and collect salaries and allowances more than is necessary for the winners to emerge by a judicial process. So it was intended to put an end to this kind of ugly situation that we had in Anambra State, and which the judiciary lamented was too bad. So that is the situation, and I think that, speaking for myself, we still need to go further, because this 180 days is still too long. I will advocate a situation where we will have a situation of what we have in Kenya, where time is shortened, and come even for better home, that no one should be sworn in until election petition is heard and determined. Because some people, once they are allowed to go in, they use the state resources to pay their lawyers. And so the lawmakers should also look into that. I will advocate that let no winners be sworn in. But if you say so, what do you say about a situation of those who are in power, who are seeking a second term, and who are contesting? So we must, that's why some of us also have advocated a transition period where you are not the one to be in office when your petition is being contested. I mean, your election is being contested, so that you don't dip your hand into the state purse in order to fight your electoral battle to the disadvantage of the loser, who does not have access to state fund. And government must also try as much as possible to make law that will bring to open the litigation costs and fix it, so that we enforce it. But I was trying to also say about what went on in Kenya, and it's something that we need to borrow a leaf. In Kenya election petition, for instance, no witnesses was called. They just front-loaded the documents and they were adopted, and trial proceeded, and within a period of less than 1 month, judgment was delivered. So I'm an advocate also that judges conduct proceedings in English language. Election petitions are filed in English language. Witness statements on oath are written in English language. Contests of these elections are usually bordered on the question of whether or not there is excessive overvoting, there is there's non-accreditation, and so on and so forth and so forth. So all that you need to produce, you can get documentary evidence, produce them, and the court should look at this document just like it was done in Kenya, and to find out whether there was substantial non-compliance with the Electoral Act and the Constitution, and if there is none, then you proceed to uphold the election, but if there is some, then you proceed to nullify the election. And I will also beg of us, the concept of substantial non-compliance and how it has affected the outcome of the election has given room to politicians to manipulate their ways, because it is very difficult for you to prove how ballot paper was snatched, how ballot boxes were tampered by persons without you being at that place. So it's, for me, in Nigeria, the Electoral Act is not in favor of losers of election.
So lastly, but not the least of my question, what would you advise lawyers who participate or take part in election petition matters, and they try to engage in sharp practices, all in the name of trying to win their cases for either the petitioner or the respondent? What's your advice to them?
Well, first and foremost, as lawyers who are ministers in the temple of justice, it's not our duty to win a case at all costs, but it's our duty to present the case of our clients within the ambit of the rules of professional conduct. Therefore, I will advise us that in the discharge of our duties, we must recognize first and foremost that we are ministers in the temple of justice. And being minister in the temple of justice, we must not do anything to mislead even the chief priest of justice, that are the judges or justices of the court, because there are repercussions. If you misbehave, you misconduct yourself, possibility exists that if petition is written against you, you are likely to appear before the Legal Practitioner Disciplinary Committee of the Board of Benchers. What will you gain, for instance, if you gain the entire money in the whole world, and you are subsequently facing the kingdom of hell in the form of having your practicing license withdrawn from you, or in the nature of having your silk, for instance, taken away from you? There is no amount of money that can buy this privilege and honor that you have as a lawyer. So it's better for you to be a man of integrity than to be a man of wealth that is earned from questionable circumstances. So my advice is that let us operate within the ambit of the rules of professional conduct, which are set out standard what a lawyer needs to do. But that does not mean that you will not do your best within the available facts and leave the rest for the judge for judges to decide.
Thank you very much, sir, for this depth knowledge on election petition issues. We're really happy that you've taken your time to talk to us today. Thank you very much, sir.
Thank you very much for having me, and I wish you the very best.
Thank you.
Thank you.
You just watch Judiciary Watch.
Because there's no program that is like this.
This is where we say goodbye on today's episode of Judiciary Watch. We will appreciate all your comments and contributions on our email and social media platform. Thanks, and always remember to stay law abiding.